Most entrepreneurs believe that when they form a company under state or national law, a BV, NV, VOF, or similar, they've created an independent legal entity. The reality is very different. These are statutory entities, created under the laws of a government, subject to its ongoing control, reporting, and taxation. Today, we're going to explore another category entirely, one that exists outside that framework: private trusts and sovereign corporate entities. An express trust is a legal arrangement created intentionally by the settlor, the person or entity establishing the trust, through a written trust instrument. It is formed under common law, not statutory corporate law. Its purpose, powers, and governance are determined entirely by the trust deed, not by the state legislature. When established correctly, an express trust exists as a private contract between the settlor and the trustee, is not registered with the state as a statutory entity, operates under the jurisdiction stated in its deed, often international common law. If an entrepreneur outside the US applies for an employer identification number, EIN, for an express trust through the IRS, they are simply requesting a federal tax identification for banking or reporting purposes. They are not placing the trust under US control. The jurisdiction remains where the trust deed states it. An estate trust is designed to hold, manage, and distribute assets of an individual, family, or estate. It is commonly used for wealth preservation, inheritance planning, and asset protection. For entrepreneurs, an estate trust can remove personal assets from exposure to business risks, ensure smooth transition of ownership to heirs without probate, operate independently of local probate courts if properly structured. When set up offshore or under a neutral jurisdiction, the estate trust is not controlled by the entrepreneur's domestic state. It is bound only by the trust deed and the chosen jurisdiction's trust law. A business trust is a trust created specifically to operate a business or hold business assets. Unlike a statutory company, BV, NV, etc., a business trust is formed under trust law, not corporate statute. Can issue beneficial interest certificates to investors instead of shares. Is governed by trustees according to the trust deed, not state-appointed regulations. When a non-US entrepreneur applies to the IRS for an EIN for a business trust, they are simply enabling US banking, contracts, or investments. The trust itself remains under its own jurisdiction, not federal corporate law. A corporation in the private law sense, not a statutory company, is a legal person created by contract or charter, not by state registration. It possesses its own independent legal personality, separate from any government, when properly constituted under private international law or a sovereign charter. These entities can contract across borders, hold property in their own name, operate without submitting to the controlling corporate laws of any single state, provided they are not voluntarily registered under such a system. This independence is why we call them sovereign entities. Their governance is internal, based on founding documents, not on legislative amendments. Limited liability companies, LLCs, and limited liability partnerships, LLPs, are typically statutory creations. However, when organized under certain jurisdictions and paired with a private trust or holding arrangement, they can operate with significant autonomy. This requires correct jurisdictional planning, otherwise, they remain fully under state corporate control. Statutory entities, BV, NV, VOF, GmbH, SIRL, etc., created by the state, under its statutes, exist only as long as the state recognizes them, bound to comply with annual reporting, corporate taxes, and legislative changes. Directors and officers remain subject to personal liability under certain conditions. Sovereign private entities, express trust, estate trust, business trust, non-statutory corporation, created by private contract or charter. Jurisdiction determined by founding documents, not automatically by the entrepreneur's nationality. Internal governance, no state-appointed oversight. Independent legal personality that does not dissolve with political change. In short, statutory entities are granted existence by the state. Sovereign entities declare their existence under private law. Governments maintain control over statutory entities through mandatory registration and reporting, taxation rules and audits, regulatory compliance and licensing. The power to dissolve the entity or remove directors. With sovereign entities, none of these controls apply unless the entity voluntarily submits to them through registration or jurisdictional choice. That is why this knowledge is not widely taught. It limits government influence over private enterprise. When structured correctly, there are virtually no disadvantages for the entrepreneur. Asset protection from both business and personal risks. Jurisdictional choice for governance and dispute resolution. No automatic subjection to changing domestic corporate laws. Greater contractual freedom. Perceived disadvantages, such as complexity or cost, are misconceptions. The real disadvantage lies in not having such a structure when it's needed. At Flanders Republic Law Group Corporation, we specialize in designing and implementing express trusts, estate trusts, business trusts, and sovereign corporate structures for entrepreneurs worldwide. Whether you operate locally or internationally, our role is to ensure your assets, business, and future remain in your control, not in the hands of the state. To explore your options, request a confidential consultation at info@frlgc.com or visit www.frlgc.com. Your business deserves more than statutory protection, it deserves sovereignty.